Hello students, today we are going to be looking at government and the topic is arms of government. There are three main arms of government that we are going to look at. The first one is the legislature, the second one is the executive, while the third one is the judiciary. Now let us start with the legislature. The legislature is the arm of government that is vested with the responsibility of making laws and amendment of laws. In other words, they amend existing laws. That is the primary duty of the legislature. Now also, there are two main types of the legislature. The first one is known as bicameral legislature. The second one is unicameral legislature. Now let us look at the bicameral legislature first. Bicameral legislature simply is the type of legislature that have two chambers. Now, what do we mean by two chambers? In other words, there are two houses in a bicameral legislature. The first house is called the Senate. While the second one is known as the House of Representatives. So, House of Reps for short. The Senate and the House of Representatives. This type of legislature is practiced in federal societies such as Nigeria. In other words, Nigeria practices federal system of government. So the type of legislature we have is what we call bicameral legislature. Now the second one is called unicameral legislature. Unicameral legislature is a type where there are no two chambers but just one chamber. In other words, while bicameral legislature have two chambers, the lower house, which is House of Representatives, and the upper house, which is House of Senate, unicameral legislature have just one chamber, and it is connected to the type of government that they practice. Hence, in unicameral legislature, they practice what is called unitary system of government. Example of countries that practice unitary system of government in Africa is Ghana. So they have a bicameral legislature. Now, that is to that. Now, the functions of the legislature includes number one, to make laws. Number two, to amend laws. That's amendment of laws. Number three, the legislature also perform what is called oversight function. That's another thing they perform. Now, the legislature is their main duty is to represent the interests of the people that vote for them. Therefore, we can say number 4 is representation of the interest of the people. As well, we also know that the legislature, they pass budget into law. They also exercise some form of control over the civil service by summoning their heads to the chamber of the National Assembly in Nigeria. So the legislature in Nigeria is also called National Assembly. In America, the legislature is known as the Congress. That is what they call the legislature in America. In Britain, the legislature is known as parliament. Although there are some other countries that call it parliament, but the name parliament originates from Britain. Now, let us look at the next one, which is the executive. Now, what is the executive? The executive is the second organ or arm of government in a democracy. What is the job of the executive? Now, the executive is the arm of government that is responsible chiefly for implementing laws that were made. They implement laws, or you can say they execute the laws. So the executive is headed by, depending on the system of government, the executive is headed by the president. For instance, in Nigeria, the executive is headed by the president. While because Nigeria practices a presidential system of government. So the head of the executive is called the president. While if it is in a parliamentary system, the head of the executive, which is the head of government, is known as what? Is known as the prime minister. Is known as the prime minister. Okay. Now, the next thing we are going to look at is the type of executives. Now, there are three main types of executive. What are these three main types of the executive? Number one, we have type of executive number one, single executive. Number two, we have dual executive, while the third one is collegial executive. Now, what do we mean by single executive, dual executive, and collegial executive? Number one, let's start with the single executive. The single executive is the type of executive where the head of the executive is just one person that is elected by the people. An example of single executive is presidential system of government, where the president is the head of the executive. He does not share his ceremonial power or his governmental power with anybody. Although he has a vice president, but the vice president is right under him. And does not drag political power with him. So, single executive, a good example of it being president in a presidential system of government. Now, examples of countries that have single executive, we have Nigeria, then we have the USA, because these countries have a president and they practice presidential system of government. We have South Africa, we have Ghana, we have Brazil, etc. Now, one of the advantage of single executive is that political power is centrally controlled. Political power is what? Centrally controlled. There is nobody that struggles with the president as to what to be done, who is supposed to be in charge, or who is not supposed to be in charge. Also, in a single executive, the president is responsible for anything that happens. So he takes the blame or the praise for whatever decision that he takes. That is what we call the single executive system in a presidential, that is practiced in a presidential system of government. Now let us look at number 2. Number 2 is dual executive. Dual executive. Now the word dual means two. So which type of executive is this where you have two heads? Now in a dual executive, you have two executive heads. Number 1 is the prime minister, or depending on what the country calls it. For instance, in Germany, the prime minister is known as the chancellor. The Germans call the prime minister the chancellor, but it's the same thing as the prime minister. So that is that. Now the second person, depending on the system too, is a ceremonial head. In Britain, the second person, who is the head of state, is called the Queen, the Queen of England. When Nigeria practiced this system in the First Republic, which is from 1960 to 1966, the second person, or the ceremonial head, was known as what? Ceremonial president. That position was occupied by Dr. Nnamdi Azikiwe. So in a dual executive system, there are two heads. The first one is the head of state, who is the ceremonial head. And I told you, in Britain, the ceremonial head is the Queen. When Nigeria practiced it, the ceremonial head was what? The ceremonial president. Now, the second person is called head of government. And in most places, the head of government is called the prime minister. The prime minister. So in a dual executive, we have the head of state, which could be the Queen, as in the case of Britain, or a ceremonial president, while the head of government is the prime minister. Now, examples of countries that practice this, we have Britain. Another example is India. Another example that practices this, we have Canada, we have Germany, etc. So these are examples of countries where they practice dual executive. Now, what are the things that we can see in a dual executive? We have seen that there are two people that hold executive power in a dual executive. Now, what is the advantage of a dual executive? Now, in a dual executive, there are one or two or a number of advantages. So what are the advantages? In a dual executive, number 1 thing is that the duty of government is not left for one person. The duty of government is not left for one person. Where you have two people taking decisions. And you know, when two people come together to take decision, they may be able to take better decision than a situation where you have just one person. So in a dual executive, two people are able to come together and they take decision. And when they take the decision, blame is not placed on one person, because there are just two of them there that takes decision. So number 3, the third type of executive is what we call collegial executive. Collegial executive. So what do we mean by collegial executive? Let's go. A collegial executive is one in which the power of government is vested on a collegiate. A collegiate, that is a group of executive members. They could be 3, they could be 4, they could be 5, depending on the system that country practices. Now, political power is vested on a collegiate. Those collegiate are executive members of the executive. Now, what they do is that they take turn. They take turn to govern the society. For instance, the collegiate could have, like, say 10 years tenure to rule. Now, within these 10 years, each of the members of the collegiate, let's say there are 5 of them, 5 members of the collegiate, each of these 5 members will take 2 years each to govern the society. They will take 2 years each to govern the society. Now, in this type of system, collegiate executive help to ensure policy continuity. In other words, what one person started, the next collegiate member will continue. The next collegiate member will continue until it has been carried out completely or fully. You understand? So, a good example of a country that practices a collegiate executive is Switzerland. Switzerland is perhaps the only country in the world or thereabout that practices a collegiate executive. They have a group of people who they call a collegiate who rule for a good period of time, after which all of them will leave, and then there will be election for another collegiate to come in. Now you can see that collegiate system of executive makes for political stability. It makes for political stability. In other words, there is stability in policy making and policy implementation. You understand? Now, in that case also, another advantage that the collegiate executive offers is that there is mistakes are minimal. Mistakes are minimal in the sense that a group of people known as the collegiate work to ensure that mistakes are minimal. So in other words, whatever thing that is brought out for the people to look at in form of policy is something that they've actually brainstormed on, they have actually worked on before they bring it out. And when they bring it out, they ensure that it continues until they finish their tenure. So now we have seen the types of executive. First of all, we saw the legislature. We said that there are 2 types of legislature. The first type being bicameral, and the second one being unicameral. And we also explained that in a bicameral legislature there are 2 chambers. The first one is the Senate, which is the first chamber or the higher house, and the second one is House of Representatives, which is the lower house. And we also said that the type of legislature that the country is practicing depends on the structure of government or system of government that is being practiced in the society. And then we told you that Nigeria is an example of a country that practices bicameral legislature, and Ghana and some other countries also practice unicameral legislature. Then we also came to the executive. We explained the executive to you. The executive is the second arm of government whose primary function is to implement the laws that the legislature made. And then we went forward to explain to you that there are 3 main types of executive. The first one we said is the single executive. The second one we said is the dual executive. The dual executive, which is 2. Then the third one we told you is the collegial executive. And then we explained to you that single executive is where you have one person in charge, while dual executive is where two people are sharing executive power, while the collegiate executive is where we have more than two people who take turn to rule or to govern the society. Now let us look at the third arm of government, but not the least, and that one is the judiciary. Now, what does the judiciary do? Let us go. The judiciary is the arm of government that is responsible for implementing laws that were made by the legislature. The judiciary implements the laws that were made by the legislature. So while the judiciary implements, the judiciary does not implement the laws made by the legislature. Sorry for that, that's a mistake. The judiciary, what they do is they interpret. The judiciary interprets. They interpret the laws that were made by the legislature. It is the judiciary that interprets the laws, while the executive, I beg your pardon, the executive, they do what is called implementing. The judiciary interprets the laws, the legislature, they are the ones that made the laws, while the executive implements the laws. So please, let's go ahead. Now, what do we mean by implementing? What do we mean by interpreting the laws? Interpreting the laws is explaining what the law means, especially when it is called to be used in a law court. In a law court. That is where they interpret the law. Now, apart from interpreting the law, the judiciary adjudicates. They adjudicate with the law. What is adjudicating? To adjudicate means to use the law to make a decision. For instance, when the law has been interpreted in the court, the judiciary, which is the judge at that time, adjudicates with the law, meaning he makes a decision. She takes a decision with the law. For instance, sending a person to prison or discharging a person based on the interpreted laws. So the job of the judiciary is to interpret the law. They interpret the law. So we go again. The first one, the legislature. The legislature make the law. Make the law. Number two, the executive. What do? They implement the law. Then number three, the judiciary interprets and adjudicates with the law. So when you see a judge saying somebody is hereby sentenced to such and such, it is a product of the interpretation of the law, which he now used for what is called adjudication. Therefore, the job of the judiciary is to interpret the law and also what? To adjudicate with the law. That is the main functions of the judiciary. Now, the judiciary, also known as the bench, is made up of the judges. The judges. Another responsibility of the judiciary is what is called judicial review. Judicial review, that's another responsibility of the judiciary. What do we mean by judicial review? Judicial review is where the judiciary takes over time the laws that have been made by the legislature and decide whether these laws are still good, are still valid for the time being. You know, there are some laws that are made, after some time they become obsolete. Maybe the situation for which they were made have been corrected or something. So judicial review is carried out to look into the kind of laws that are being made by the legislature to ensure that they are consistency with the things that are happening in the courts. So that is what judicial review. Now, the judiciary is also known as the last hope of the common man. You know, a society where justice is not well served, the common man, being the ordinary citizen in the society, will suffer. So the judiciary is also known as the last hope of the common man. They are also known as the custodian of the law. They are the custodian of the law. They are also the watchdog, also known as the watchdog of the law. Now, in a case where the judiciary is faced with the dilemma where in a particular matter in the court they don't have a law that directly speaks about the matter, or there is no law that can be used in a particular situation, maybe the legislature has not made that law, the judiciary is at liberty to create its own law in the courtroom and use its own law to pass judgment. Now, the kind of laws that are made by the judiciary, which were not made by the legislature, is known as judicial precedent. Another word for it is case law. So, in a situation where the judiciary or the judge cannot find a law that directly speaks to the matter which he is handling, that judge has the power to create his own law, make a law for that purpose based on morality or, you know, social public view or social justice. Now, when they make that law which they use in the court there is what is known as what? Judicial precedent or case law. So we can say judicial precedent is the type of law that is made by the judiciary in the event or situation where there is no law that directly speaks or relate to the matter that they are handling presently in the court. So today we have seen the organs of government. Number one, we have seen the legislature. We have also seen the executive. We have also seen the judiciary, and we have explained the legislature as the body responsible for making laws. We said there are two types of legislature. Number one being the bicameral legislature, and number two being unicameral legislature. Then we also saw the executive. In the executive, there are three types. The first one is single executive, second one is dual executive, and the third one is collegial executive. Now, we saw the judiciary too, and we said the judiciary is the body that interprets law. While the legislature makes the law, the executive implements the law, the judiciary interprets the law. Another thing that the judiciary does is adjudicate with the law. In other words, they use the law to pass judgment. Then, we said also that the judiciary makes what is called judicial precedent, especially in a situation where there is no law that directly speaks to what they want to do. Thank you very much, class. We are going to see another time, but make sure that you do your review, you ask your questions, and I will be ready to answer your questions.